Welcome to the Data Protection Law in Peru. Today, we delve into the dynamic world of personal data protection laws in Peru, focusing on how they have adapted over the years since the inception of the PDPL in 2011. As images of diligent lawyers, powerful computers, and striking symbols of law and data flash on your screen, our endeavor is to enhance your understanding of the legal framework that governs personal data protection in Peru. Let's delve into the guiding principles that govern the processing of personal data in Peru. As outlined in Article 4 of the PDPL, these principles include consent, purpose, proportionality, quality, security, availability of recourse, adequate level of protection, and the principle of accountability. Notably, the recent Supreme Decree 0-029-2021 PCM introduced two new principles: transparency and proactive responsibility, aligning Peru with international standards, particularly the European General Data Protection Regulation, GDPR. Now let's discuss the concept of processing personal data, encompassing operations like collection, recording, organization, and more, as defined in Article 3 of the PDPL. Article 5 outlines conditions for processing, emphasizing the need for prior, informed, express, and unequivocal consent. Notably, Supreme Decree 0-029-2021 PCM raised standards for consent, making it explicit that benefits or prizes cannot be offered in exchange. Moreover, each processing purpose now requires separate, granular consent. Moving on to the rights of data subjects, as per Article 18 at SEC. Of the PDPL, individuals have rights such as access, rectification, cancellation, opposition, information, revocation, and portability. These are the basic principles of data protection in Peru. Recent modifications, specifically the new regulation of law, number 29733, Personal Data Protection Law, added the right to portability, allowing individuals to transfer their personal data from one controller to another, given certain conditions are met. Let's explore the obligations related to personal data banks. These banks, defined in Article 3 of the PDPL, are organized sets of personal data, each with distinct ownership characteristics and applicable regimes. Owners and persons in charge have specific obligations, including registration in the National Registry of Personal Data Protection, maintaining security measures, and reporting data security breaches. Shifting focus to the National Authority of Personal Data Protection, NAPDP, this body ensures compliance with the PDPL. Article 33 outlines its functions, such as issuing rules, supervising data processing, and imposing sanctions for non-compliance. Legislative Decree 1353 brought changes to the NAPDP's organizational structure, making it an autonomous entity attached to the Ministry of Justice and Human Rights. As we conclude our exploration of the National Authority of Personal Data Protection, it's evident that these regulatory changes underscore Peru's commitment to strengthening data protection measures and ensuring accountability in the digital age. In conclusion, we've covered significant changes in Peru's personal data protection law. These changes offer enhanced protection for individuals and businesses. As we navigate the challenges of a digital era, it's crucial for businesses to implement measures like privacy policies, appoint a personal data officer, maintain a register of processing activities, and develop security protocols to ensure compliance with the PDPL and prevent potential sanctions or claims. To protect your personal data,